Judiciary of the Maldives. The judiciary of the Maldives has been a systematic institution throughout the history of the nation. It has always been an institution which is under the full control of the head of state and is still in some degree. However, a radical change occurred during the past decades. The introduction of the English legal system into the country, a result of the Maldivian society coming in close contact with the outside world. And consequently, the present legal system of the country is a mixture of not only Sharia and customs, but the English legal system also. Pre-Islamic history. The early and medieval history of the Maldives were ignored until the recent times. There are few works on the early history of the country. They are, however, not completely reliable due to lack of historical evidence and immense references to folklore. The judicial system, which took a new direction after the country embraced Islam in 1153 AC and is a predecessor of the previous system which had evolved centuries ago. According to Allama Ahmed Shahabuddin of Adumitu, the son of Adubodu Fanandiaro Tagurfano, the first inhabitants of the Maldives, the Deviers, came from around 4th century BC and had a leader whom they called Shwamia. The Shwamia was the religious leader of these people. They thought that the Shwamia was an agent of God, and hence in their social organization he held absolute power of life and death over the people. He was the authority of the affairs. All disputes and conflicts, whether between two government officials or a government official and a common person, or between two common people, were decided by Shwamia. When we take the above accounts into consideration, we know that from the earliest times, the people living in the Maldives had a system which was functioning as a judicial body. In the system, the judge was the leader of the Shwamia, and the court might have been the leader's official residence. It may be assumed that the society would have been governed on the basis of some prevailing customs and traditions. According to Isho Lumafarno, a historical document of Maldives written in 1195 AC, there was a set of customs implemented as law in the country when Islam came in 1153 AC. This set of customs was known as Purorodin. From this report, also we can deduce that a system of laws was evolved from the very beginning of the Maldivian society. Within a century after the colonization of the Maldives by the Deviers, another wave of travelers came from India and started to occupy the country with the former. The merger of these two people led to a development of new society and finally gave rise to an authoritative monarchy. This is the time when the dictations of the king started to absolute the main source of law in the country. Islamic history. Islam became the official religion of the state of the Maldives with the conversion of King Timiush Mohakal Miniang into the important faith in 1153 AD. As mentioned before, the earliest documentary evidence of the Maldivian history of this period is the Isho Lumafarno. This document refers to a Pediaro and Utu Pediaro. It can be easily concluded that the present noun given to a judge in the Divé language, Fediaro, is an evolved version of Pediaro. It can also be argued that Divé, noun for Supreme Judge Utama Peniaro, is a developed version of Utu Pediaro. The Pediaro, the judge, was an esteemed and respected leader of the society. This can be understood from the references in the Aistu Lumafano, Hen Hanai Tarika Takai Divehi Raji, has the following words to say. The novels listed as testifies in the Ishadu Lumafano were people of a high caste in the society. The powerfulness of the judges can be understood from the incident recorded in Ishadu Lumafano. According to this report, the judges issued orders for some Buddhist monks of Ishto to be brought to Mail and beheaded. The orders also included a commandment to demolish a monastery in the same island. According to the report, these orders were executed as directed by the judges. The reports in the Ishto Lumafano also indicate that the judge did not meddle with other political affairs of the state. This fact does not mean that the indiciary was an independent institution in the political organization of the Maldives. But the institution involved in the administration of justice was a completely realized institution with the judges concerned only about their task as judicial officials. The same document also refers to an official called Dendana Ayaka, who was responsible for implementing and executing the judgments and decisions of the judges. The above reference show that during the first century of the Islamic era of the Maldives, there were judges who were specialized in administering justice, and that they were special officials who were responsible for implementing the judgments of them. The judiciary of the Maldives was a separate institution in the political organizations of the country. As aforementioned, according to the Ishho Lumafano, a set of customs called Purupurudin was implemented as law in the country before the coming of Islam. From the same source and later historical records, it is clear that after Islam, the Islamic Sharia gradually became the main source of law in the country. However, many years after Islam, the Purupurudin still played an important part in the judicial system. Historical sources also say that the king was himself an authority. His decrees were treated as law and were implemented through the judicial system. During the first century after Islam, the judiciary therefore underwent a radical change with a completely alien system of law being introduced. The years which followed saw the operation of three main sources of law in the country, namely the Islamic Sharia, the decrees of the king, and customs. Since Islamic Sharia has introduced gradually, it caused the rules of Sharia to be altered by local customs. The Islamic Sharia was never implemented in the country in its complete and pure form. One example is in the dress code of the Maldivian women. Although the Sharia has specific commandments on this matter, accounts of historians like Ibn Battuta and Ferencua Pirot that these commandments were not implemented in medieval times. As for the duties of the judges, they were required to be true with both the Sharia law and also Purupurudin. Therefore, the judges in the country was a scholar not only of Islamic law, he was also well versed in the customs and traditions of the Maldivian society. While writing about the history of Maldives during the period of the 9th, 12th centuries, H.E.V. Bale quotes from the famous Arab traveler geologist Ali Idrisi, 1099 to 1186. The king's wife administers justice. Was the king the highest authority of administering justice from the beginning of political organization? After Islam, did the queen rise to that position in the political arena of the country? Did that particular queen did that particular queen have an extraordinary influence on the administration of the state? There is not enough evidence to make a conclusion on this point. What is known is that no mention is made of the queen being the highest authority in administering justice in the country in any other document or in folk evidence. The great traveler Abu Abdullah Muhammad, commonly called Ibn Battuta, visited Maldives in 1343 AC. In his records, he writes as follows: they call the judges by the name of Fadiaro Kalua. They go to the Fadiaro Kalua to settle their disputes. He is the most highly esteemed and respected person among them. His words were like the decrees of king himself, and even stronger. He sits on a special carpet in the palace while hearing cases. He would own 3 islands, and the income generated in this island would be his income. From the above quotation, it can be understood how powerful the judge was in the political organization of the country. The conclusion is further strengthened by the following statement: when I married this lady, the daughter of Suleiman Mia Wazir, the Wazir forced me to become the judge. There are no many big conflicts in this country as well as have in our lands. The first evil custom which abolished was a judge was the custom of women remaining with their husbands after they had been divorced. I completely uprooted this custom. Besides this account, Ibn Battuta also tells us that about certain un-Islamic customs that he abolished by issuing rulings. We can assume that these judicial rulings should have been implemented by the Dandana Ayaka or some other officials who were in charge of implementing such rulings. Ibn Battuta had written reports about the procedure of trial also. If 2 people are to be brought before the judge, they would be ordered to do so in writing. When this order was issued, the parties should present themselves before the judge as directed. If anyone failed to do so, he would be duly punished. Ibn Battuta further says that if a person did not want to or could not be present before the judge, he could send someone to represent him. If the defendant was able to issue a representative to speak on his behalf, it possibly means that the practice of lawyers representing their clients was there in the Maldives during those days in some form. According to Ibn Battuta, when the king felt that a case was to be recognized, perhaps on appeal, then the case would be tried again in the presence of the king and 3 Bodu Bekalan by the Utu Fadiaro, perhaps the Supreme Judge, and Bodu Naibu or the Quati. The report makes it clear that there was a kind of an appeal system also. The main points of note from the accounts of Ibn Battuta: the judicial system of the Maldives was developing and evolving. It may be incorrect to say that the system was a highly efficient system during this time. But then the reason was that the Maldivian society was lacking a proper education system and an efficient social structure. Also, the fact that the population was divided between a number of islands, with each island having a group of few hundred people, was a significant factor. As the proverb says, necessity is the mother of invention, and there was never a necessity for a highly complex and comprehensive judicial system to evolve. Some people may argue that the political supremacy of the monarchy also prevented a judicial system to developing into a highly efficient and development political body. Francois Peyrat, another foreign writer who has given considerable accounts of the medieval judiciary, came to the country in 1602 AD, and about 4 centuries after Ibn Battuta. Unlike Ibn Battuta, Peyrat shed light on the judicial operation in the atolls also. He says that each atoll is a separate province. The person in charge of each atoll is called Bodu Naipu. These Bodu Naibs are the leaders of the province. He is responsible for implementing the religious laws. He has an obligation to manage the education system as well as legal affairs. As he is over other naibs in the province, since the naib is the absolute dictator over the province, he is responsible for deciding both criminal and civil matters. If someone wants to file a case, he has to meet the naib. The first amendment to the Constitution of 1953 was made in 1954. The latter also gave the same provision on the judicial system. It did not give the judiciary the status of a separate organ, and provided that the king was the highest authority in the administration of justice. The Constitution provided that the judge was to be responsible for administering justice in the name of the king and also to uphold the banners of Islam in the country. No changes were brought to the structure of the judicial system until a new constitution was again declared in 1968. This constitution divided the powers of the state into 3 organs, namely the president, the cabinet of ministers, and the people's majlis. Here again, the judiciary was not considered as a separate organ of the state. There was a separate chapter which includes provisions regarding the judiciary. The first article in this chapter provided that the administration of justice would be in the hands of special officials appointed by the president. The responsibility of upholding the banners of Islam imposed by the previous constitutions was lifted from the judiciary by this constitution. This may be a step towards a higher level of specialization of the judicial system. The amendments brought to the Constitution of 1968 did not bring any changes to the pattern of the judiciary. It is the new Constitution of 1998 that was established the judiciary as a separate organ of the state of the Maldives for the first time. This is obviously a major change to the structure of the judicial system of the country. This constitution provided that there still be a high court in the Maldives and that the high court would consist of chief judge and a number of judges appointed by the president. It also provides that there shall be courts of law in the Maldives, the number of which would be decided by the president at his discretion, and that there shall be judges in these courts appointed by the president. The Constitution also gives the president the highest authority in the administration of justice. Based on this provision, the judiciary is still under the control of the head of state. Therefore, judiciary is not an independent organ of the state in the Maldives. Rather, it is a specialized organ of the state which deals only with the administration of justice. Court system during the constitutional period. According to the present structure of the Maldivian judiciary, the High Court is the highest authority in the administration of justice, and this institution is directly under the control of the president. However, the lower courts are under the Ministry of Justice, a limb of the executive organ of the state, and not under the High Court. The Ministry of Justice came into being in 1909 in the form of Mahkamah al-Sharia. This institution evolved to become the Ministry of Justice in 1968. When the Mahkamah al-Sharia came into being, 6 officials were there in the Mahkamah to adjudicate in legal matters. In 1955, the Mahkamah was reformed and the administration of this institution was strengthened. In accordance with the new system, 3 levels were created in the Mahkamah, with judge and a naib for each table. During the same year, a legal commission was appointed for each ward of mail. In 1966, the tasks of the Mahkamah were divided, and Thana later from Ta and Alif, Ha and Alif, which given to each section of the institution. In accordance with the new arrangement, Ha was the section of Chief Justice. During the same year, the section were numbered from 1 to 7. Later, some changes were brought to these arrangements, and finally, in 1980, the 8 divisions of the Ministry of Justice were converted into 8 courts, with a numerical number given to each of them. Until the present constitution, the court system had been like this. However, with the present constitution, a major change occurred, with the 8 courts being abolished and a completely new 4 courts coming into being. These courts are the family court, the criminal court, the civil court, the juvenile court. The function of this court can easily be implied from the names. The family court is concerned with all family affairs in general. The criminal court decides in criminal cases, juvenile court in all cases in which children are involved, and the civil court with all civil cases except family affairs. Separate offices for legal officials or the naibs were created in the atolls in 1962. During this time, the office of the naibs was established each island. Later, an atoll court was established. Atoll court was established in each atoll in 1970. In 1979, all the atoll courts and naibs offices were abolished, and an island court was established in each island. Since then, a major change has come about in the judicial structure of the atolls. With the Constitution of 2008, the Maldivian judiciary has entered a new phase of transformation and progress. Under the Constitution, the Maldivian judiciary is as independent as it has ever been, and the current Constitution established for the first time in the history of Maldives a Supreme Court and declared it the highest institution of the Maldivian judiciary. The structure of judiciary as follows. The third level in the hierarchy stand for superior courts in Malay. Magistrate courts are located in the administrative divisions of the atolls of the Maldives, with a magistrate court in each inhabited island. At the moment, there are 194 magistrate courts in the country. Thank you, viewers, for watching. I am Shamim. This article is taken from Wikipedia.